Okay, so I'm going to get us started. More people may join, but welcome to a tax policy discussion at the Adler School of Law at UBC. We're very pleased to welcome Mr. Michael Lennard today to present a seminar for about 90 minutes. Just as some background, this tax policy speaker series is part of a course that's taught to UBC, JD, and LM students. But because of the prominence of the speakers and the importance of their topics, we open the seminar to the public. It's going to go up to 12:30, and the general format is there's a presentation at the beginning by the speaker lasting between 30 and 45 minutes, and so we allow some flexibility, and there will be a robust question and answer session. You can insert your questions in the chat box, even during the presentation. And I will be monitoring the chat box questions. And also I'll be moderating the Q&A session. A quick introduction to today's speaker, who especially among the international tax community needs no introduction, but Michael is the chief of the International Tax Cooperation section in the Financing for Sustainable Development Office of the United Nations. He's also the secretary of the United Nations Tax Committee. He'll be telling us a little bit more about the committee. His work focuses on ensuring the fairness and workability of international tax norms, including achieving greater developing country input into these norms, and then encouraging cooperation to improve tax systems as a spur to sustained development that benefits all stakeholders in tax systems. He currently leads the UN Secretariat work on transfer pricing and on taxation of the digitalized economy. He has also been responsible for the Secretariat level work for the 2017 updates of the UN Model Tax Convention, as well as the United Nations Handbook on selected issues in the taxation of extractive industries. Michael also had a prior career as a policy advisor at the OECD and in the Australian government. And so if you Google Michael, these earlier experiences will show up. With that, Michael, I'm going to give the floor to you because I've looked at the slides. You have a lot to talk about. And so let's make sure that we have time for all of that.
Thanks, Wayne. Thank you to the university and thank you to participants. I'm going to, first of all, mention that I'm speaking entirely in a personal capacity, not speaking for the UN. I'll try to be as frank as possible with a lot of the issues that are in discussion in the UN, but of course there are still some discussions which are not yet public. There should be a paper, for example, at the end of this month, or more likely early next month, which will be public with a final version of the Article 12B proposal, which I'll talk about later. So speaking just for myself, and I'm not going to read every slide, there are a lot of slides, it's more of a takeaway for you. I'm just going to alight dealing with a very big subject on some of the issues, and then you can ask questions on particular aspects. First of all, I always start with the UN context. I'll talk a little bit about that, then I'll talk a little bit about the wider environment, the multilateralism versus unilateralism issue, which you hear a lot about at the moment, or uncoordinated unilateralism, as it's often referred to, and some of the things in between, including bilateral model treaties and bilateral treaties themselves. I'll then talk a little bit about the proposed new Article 12B in the UN Model Tax Convention on Automated Digital Services, where that's at and what its main features are. And then I'll talk a little bit about the Facti Panel report, which you might have seen, and how it relates to the UN tax work. It's an independent panel and an independent secretariat, in fact, but I'll just mention a little bit about that, and then we'll have Q&A. So, first of all, what is the UN context? Well, the UN context for its tax cooperation work is that it's part of financing for development, or financing for sustainable development, as it's often referred to, and that development needs to be financed. Now, what that means for us is that there are three main aspects of that. First of all, developing countries, and our focus is particularly on developing countries, important things like schools and hospitals and roads and so forth have to be paid for. So domestic resource mobilisation is a really important part of financing for development, meeting the Sustainable Development Goals, and tax is a very important part of that. And looking at issues like hospitals now, financing recovery from COVID-19, financing vaccines, for example, it's a very important issue at the moment, as important as ever, maybe even more important. Another aspect is that foreign direct investment is important for development. And we're not anti-business. Sometimes we're treated as being anti-business, but we're not at all. We work closely with business because we recognise that foreign direct investment is important for development and a good partnership between multilateral multinationals and governments and the citizenry can actually be a very important part of development. Thirdly, we always look at these issues through what we call the systemic issues. What's the voice and participation of developing countries in norm setting? That's an important tax focus at the moment. You know, are developing countries sufficiently being represented in the rulemaking, the norm setting, and the norm development on taxation? I'll talk a little bit about that as we go along. UN Tax Committee has 25 members nominated by governments and acting in their personal capacity. There's been pushes from the developing world generally to make it into an intergovernmental grouping. At the moment, it's not. But the reality is when they're appointed, most or all of the members are actually serving or sometimes ex-members of government. But certainly we seek, when the Secretary General makes his decision, to have a diverse grouping that is fully sort of representative of the different approaches which are taken around the world to many of these issues, including on digital taxation. We also seek geographical representation. There's no set geographical numbers for different areas of the world, but you generally find there's a group of about 5 from most regions, sometimes 6, sometimes 4. So what is the committee doing? It has a term of 4 years. This membership of the committee ends in June of this year, and we've already begun the process for the next 4 years membership, where countries nominate people and then the Secretary General will make a choice. And in fact, the deadline for nominations is next Monday. So we're getting a lot of late nominations at the moment. The Tax Committee has a very broad mandate in international tax cooperation, and the main thing is that it has to give special attention to the situations of developing countries. And here's the web page here, which is the home page for the committee. And you'll soon find papers for the next session of the committee, which will be in late April, beginning on the 19th of April and going through virtual. It'll be virtual until the 28th, and then a special UN tax meeting on the 29th. The Model Tax Convention is one of the most important products of the committee, and you'll find the 2017 model there. The 2021 model is almost being finalised, and one of the big issues will be how it deals with taxing the digitalized economy. More on that. Basic difference with the OECD model, there's more preservation of source, as we call it broadly, source taxing rights, more of a preference for withholding taxes than in the OECD model in particular. But there are certain aspects where we've actually influenced the OECD model in terms of offshore indirect transfers, for example. It's been very influential of some of the work that's been done since by the OECD and also by the Platform for Collaboration on Tax, which is the OECD, the UN, the World Bank and the IMF secretariats. So recognising that many countries have both taxing rights based on residency and on source, and that those have to be distributed under a treaty to make sure you don't get double taxation or multiple taxation. More is generally retained by the source country from where the payments are made, for example, on interest, dividends and royalties, and on digital, as we'll see. more is retained by the source country and credit or exemption is required by the residence country. As I've mentioned, there's a lot of support for withholding taxes in the committee, generally on gross, and the reason is the simplicity of them. And they also feel, a lot of countries, that profit-based mechanisms can tend to be too much subject to profit shifting and manipulation. As I've mentioned, it is an influence of international tax norms. And often when you look at, for example, the 2017 fees for technical services provision, which said that there should be an allocation to the place where the service was provided to, where the payment for the service was made, that doesn't require permanent establishment. That was quite a big step forward. It's something you won't find in the OECD model. I think eventually you'll find something like that in the OECD model, but some years hence. And I think that was a harbinger of more importance of the market. And that was very hard fought, and a lot of countries, a lot of members, I should say, didn't like that. And one of the beauties of the UN model is they get to say if they don't like something. In the commentary, there's quite a detailed discussion of why some members of the committee didn't like it. And in saying that, that's been influential, and there's been studies which show that since that UN provision on fees for technical services, that it's been sought and achieved more by developing countries. The first thing to bear in mind is that it actually drew upon developing country practice. The UN Tax Committee doesn't usually just completely develop something afresh. It's usually based on developing country practice. And then it makes it easier for developing countries to argue for that provision. And they have all the arguments, and they also have the arguments against, so that they can meet them in a negotiation. And even if you don't like a provision like fees for technical services, Article 12A of the model, or the new 12B, or the projected 12B on automated digital services, there's still some benefit for you, for example, as a multinational, in having some sort of consistency in how the language that's used, and as I say, also having the arguments against. Now, how do people see the way forward on particularly on digital taxation? And when I talk about that, when you talk about taxing the digitalized economy, often the next step is that someone will say, well, because the whole economy is digitalized, we're really talking about taxation of everything. That's an issue which comes up in our work on digital. But effectively, it's a very big argument. And the future of tax norms and of tax norm setting are in play in some respect in the current discussions. This is how some people see the situation. On the left, you've got the inferno of uncoordinated unilateralism, chaos, and as I've said, damnation, which they sort of imply. And on the other side, you have the light of the heavenly light of Pillar 1 and 2 approach to the what I call the comprehensive multilateral approach. And this is often how things are put in stark terms. And of course, the reality is that we would like that there be a multilateral consensus on some of these big issues. Everyone would want that. Everyone would want a consensus that's deeply felt, and that is felt as being fair, and from our point of view, particularly between developed and developing countries. We'll come back to that in a minute, that issue of how much consensus we have. But multilateralism is not perfect. Big bang multilateralism, as I've called it, is slow. Even if you have agreement in July on the basics of Pillar 1 and Pillar 2, for example, it then has to become a treaty, and the outstanding issues have to be dealt with. You need the supporting interpretive pages, and which are very important, as anyone who knows the Vienna Convention on the Law of Treaties knows. Then it has to be settled as a treaty. Then it has to come in force as a treaty with enough countries participating in it. And then for an individual country, it has to come into force domestically for you as a country. And you can never also be sure who's going to actually join. You know, I hear a lot of people, and maybe some in the audience, have said, well, the US will never join a bilateral treaty with Article 12B in it. And the question I ask of them, of the US or any other country, is, you know, how certain are you that the US will sign on to a multilateral treaty? You know, it might participate in negotiations, or any country might participate in negotiations, but it's by no means certain that at the end of the day they will actually join up on a treaty. You don't know that until basically until they make a decision, which could be years away. So one of the things which developing countries are very conscious of, and a lot of people are missing, is that why, if we have a unilateral approach, why should we withdraw that unilateral approach merely when there's a mid-2021 consensus on the basic parameters of a multilateral agreement? Because that won't bring in any money. Bringing in any money will probably be years hence until the multilateral has enough countries involved and developing countries have joined up, and they know who else has joined up as to whether it's worthwhile for them to join up. And even then, some of them may not join up. And in their case particularly, you know, why they often say, would we give up a unilateral approach until we actually had money coming in from a more multilateral approach? So just when you hear that, just be aware of that issue, that a lot of countries are seeking money at the moment because of COVID particularly, and there is a policy issue. At what point would they choose to withdraw their unilateral measures? Multilateral also can tend to be fighting the old battles with old methods. Some people say it's difficult to have a systemic reform through a multilateral treaty. I don't know that's necessarily the case, but certainly with tight deadlines where we've got, it certainly does make it harder to have a more systemic approach, a more thorough analysis of what we really are seeking from international tax norms. It also could be outdated when it's completed, because one of the reasons for all this work is that the way in which business runs has changed, and that might happen even more so in the next few years. Multilaterals are hard to keep up to date with that sort of thing. And I know these are all issues that the OECD, which I used to work with and have great respect for, are aware of, but they are issues. Might also be harder to have a multilateral agreement at the moment. Theoretically, it's easier for countries to participate, but it may be harder for people working at home in developing countries, but also in some developed countries, to fully participate. And time zones tend to favour Europeans, maybe some other areas of the world. Africa is often on a similar time zone, but certainly I know Asian participants in these events do find it hard to participate, and there's often limited English language documents, sometimes limited interpretation, and we've had some of those issues ourselves. I won't deal with every issue dealt with there. So as I said, in a world of deep consensus, a multilateral convention reflecting that consensus is really the best thing. And we do wish the OECD and the Inclusive Framework all the best with what they're doing. But what has happened is that some of the developing countries in our committee are basically saying, you know, maybe what's on the table at the moment is too complex. Maybe maybe there's not enough on the table, and we also don't know who's going to, how it's going to end up looking, and who's going to join. And also, some of them feel that in the discussions at the moment, the idea of taxation on the market is not given the legitimacy it should. It's almost treated as a gift which will be given, rather than something that in international economic law is quite legitimate. There's nothing legitimate with it, illegitimate about it, and it's not contrary to general tax principles. So it shouldn't have to be defended as though it's contrary to tax principles, but if you give us some market taxing rights, we'll be happy. It should be recognized it's a legitimate taxing principle. And even if it's limited for the benefit of avoiding double taxation, its legitimacy as a general principle shouldn't be put into question. Just a couple of points on multilateralism. This is a German writer, Mull, on multilateralism, and he has some quite interesting ideas about multilateralism, including that that often it's about which principles, values, and organisations should determine the international order and thus shape international politics, international tax politics, maybe in this case, and that's quite interesting when you think about what does multilateralism mean in the context of taxation, and what's really happening with multilateralism. And this is another interesting comment from the same author, that occasionally there is talk of a multilateral system that must be preserved. This system is, in fact, the liberal Western-style international order of 1945 in its renewed version of 1990. And in the tax context, some people say, preserving the multilateral system, we have to make sure it's not just an assertion of the existing state of things, the existing power dynamics, the existing approach towards market taxation at the level of treaties. The things have to change. This is just a diagram to remind people that so much emphasis is put on pillar 1 and 2 of the OECD inclusive framework. And also to some extent the top bit, which is the dispute settlement, the roof, less is on the enforcement mechanisms in this area, but also I think not enough attention is paid to the floor, which is the interpretive apparatus and the materials. And for all these things, you've got to say, well, who are the drafters of all these things? Who are the decision makers? Who makes the decision about what gets into the interpretive materials? And formally, it will always be the inclusive framework. Formally, it's always the committee in our case. But who are making who are the influences on these things? And that's something that you need to think about for any norm setting, including UN norm setting. And then on dispute settlement, you have to think about, if there's a panel, if you can't set up a panel, who makes the decision about who presides over a panel? All these things are important. If there's a disagreement, will there be enforcement? Will it be collective enforcement or not? And there hasn't been much discussion, particularly of the enforcement mechanisms in the wider discussions, and also of the interpretive materials. And they will be very important, particularly if you have a binding form of dispute settlement. It'll be very important what the interpretive materials say. It'll be very important who the dispute settlement panels, or who run those dispute settlement panels. Just a final point on this quickly is that from our point of view, we don't see this issue as merely multilateralism versus unilateralism, or multilateralism versus bilateralism, as in bilateral treaties, because we see that there's a whole range between uncoordinated unilateral measures towards coordinated measures, bilateral measures, regional approaches, plurilateralism, which is a trade term for where several countries take the lead, rather than try and get everyone agreeing on a particular approach, and then what I call Big Bang multilateralism. The multilateral, comprehensive multilateral treaty that so many people are talking about. And in our view, all of those elements can be affected by multilateral approaches. We see our work as multilateral. We're getting together with people from different experiences, nominated by countries, with the sort of authority of being within a 193 country body, the UN, even though they've decided for various reasons, including convenience of discussion, that there be a representative group of 25 to deal with that. That's, in our view, is essentially one expression of multilateralism. And that multilateralism both influences domestic law, influences hopefully any ultimate treaties, but also is influenced by what's happening at the unilateral level as well. It's not just multilateralism or bust in our view. There's very there's many layers to that onion, and that's what we call connected multilateralism. And I won't go through this slide, but there's a lot of pros and cons on different approaches within that range of options, including things like speed of development and global coherence and so forth. But that's each of them has their pros and their cons. Is unilateralism so devilish? It is treated as though it's very devilish, but it can be more responsive to a country's public and specific situation. And good unilateralism is aware of the impact on foreign direct investment, is aware of the impact on the ability of multinationals to do business in that country and more broadly. But also unilateralism can reflect citizen demands for change and political currents. You know, we see in many countries today, when a new government comes in, there's a new approach. And, you know, there's some legitimacy in countries being able to respond to that in terms of their domestic legislation. Of course, some due recognition has to be made to the fact that businesses need to plan for the long term and so forth. But we need to be responsive to our citizenry. The unilateralism has also played a big part in OECD responses. Anyone who knows the history of the UK patent box and the BEPS work related to that, and importantly the US GILTI, for example, will know that unilateralism has fed into multilateralism there and in the UN work as well. And just a final point, that the so-called uncoordinated unilateral tax policies, such as digital services taxes, are criticised. And whether you believe that or not, there's far less criticism of what you might say as uncoordinated unilateral trade policy. For example, the US Section 301 is a unilateral measure. It can be contested in the WTO, but because the WTO dispute settlement function has not been working for reasons which some of you will be aware, that the appellate body is a consensus. It needed a consensus to have judges appointed to that, and we don't have a quorum in the appellate body because of the lack of consensus. And that's not to criticise Section 301 or any country, which I would never do, but it's to say that, you know, we seem to hear less criticism of uncoordinated unilateral actions when they're either introduced into a more multilateral approach or a proposed multilateral approach, and secondly, when they're in the trade area in terms of unilateral trade retaliation. 12B is something the Secretariat proposed work on the digitalized economy some years ago. I'm proud that that's part of the legacy that I proposed, that there was a role for the UN to be working on this issue as well, not just the OECD. And particularly with the emphasis on the UN is very much a developing country focused organisation. But this is very much the work of the committee. And the draft that you've seen, which is the most recent draft, is which I made available and you should all have, was developed by developing country participants, and about half of the committee was involved just in the drafting of that. And that currently is the majority of view because the majority of the committee voted that something of this sort should go into the version of the model to be completed in April. But it still has to go before the committee in April to see what form it takes and how how it expresses some of the differing views. And one thing that we do in our model is we do have the country view. So we will have the view of the people from essentially from the developed world who say we don't like this provision, we think it's bad for foreign direct investment, we don't think it's very workable, we think it taxes more than it should, for example. That will all be there as it is for 12A, which is a good model on fees for technical services. In the next version, you will see, probably early in April, the version which will go before the committee for approval. The main thing is it expresses the concern that the modern means of telecommunications have made the PE requirement inappropriate, that presence in the market should be sufficient, economic presence in the market effectively, and you shouldn't require some of these very arcane rules on permanent establishments. Just as Article 12A a few years ago in the 2017 model take the same approach for fees for technical services. There shouldn't be a permanent establishment requirement. And I do have a bit of a hobby horse in that there's talk about the uncertainties of new approaches and uncertainties if you get rid of the PE requirement. But anyone who's read books on PEs and the many articles that have been written knows that the concept of a PE is not an entirely clear concept. It's not entirely consistent amongst different types of PEs. You even have deemed PEs in a lot of developed and developing countries for insurance, for example, which aren't really PEs at all. And you have different times and timings and so forth. So we don't have a perfectly coherent system of rules at the moment, and they're not perfectly coherently interpreted from country to country. So the fact that there will be some uncertainties in a new approach sometimes neglects the fact that we've got uncertainties at the moment. This is the draft. It will be an option. It has to be negotiated. It'll be a shield, not a sword. You'll need underlying legislation to be given force to through the treaty. The treaty doesn't give a taxing right. It protects that taxing right in the treaty from being overridden effectively. It preserves that taxing right. And as I've said, it will express the pros and cons, the nature of the model. The general scheme is that, first of all, income from automated digital services arising in a contracting states, that's made clear what that means later, and paid to a resident of the other contracting state can be taxed in the state of the resident. Okay, that's fine, that's normal, but paragraph 2 said it may also be taxed in the contracting state where it arises. And later on, that's defined to be where the payment is made in respect of it, at a rate to be established through bilateral negotiations. And the suggestion in the commentary is keep it modest. We don't want to strangle business, keep it at 3 to 4%. People will vary on whether that's modest and how modest it is, but the committee is trying to be reasonable and to integrate those different elements of sustainable development, including foreign direct investment, but saying where profits are being made in our country through engagement with our market, we think we should have a reasonable return from that, which can then be used to lift people up out of poverty and to deal with things like hospitals and education, which are important for our people. Paragraph 3 is very interesting. The paragraph numbering will probably change in the final version, which you'll see in a few weeks, because of some clarifications and elsewhere. But the main scheme will still exist. And paragraph 3 says, which is unusual for the UN model, again, to recognise the importance of foreign direct investment, that the beneficial owner of the income from automated digital services, the payee, can request to subject its qualified profits, which is essentially profits before tax, from automated digital services to tax at a rate provided in the domestic law of the state. So effectively, the business receiving the payment can say, well, we didn't actually earn the amount of income which you would think from applying, looking at the gross, and therefore it's more appropriate to look at the actual profits we made. And this complicates things. It's always more complicated than a pure gross withholding tax. It's unusual for the model. It wasn't in Article 12A, but it's an expression that they do want to actually address some of these issues. And the qualified profits is 30% of the amount applied to the beneficial owner's automated digital business segment to the actual revenue they're getting from the automated digital services. And effectively, for those who know the Massachusetts formula, that's effectively recognising that sales, assuming that sales and assets and payroll are all about equal contributors, that this is reasonable to say 30% can be attributable to sales. Of course, it's not a scientific figure, but it's an attempt by the committee to say, well, let's try to do something for the businesses that might be in not be losing if they are taxed based on gross profits, but let's try to make it not too complex and therefore somewhat formulaic. There are some details about what happens if the segmental accounts are not available, but I won't deal with that at the moment, and there'll probably be some further discussion of that in the next version of the article. There is some concern about abuse, and there is a provision there that when the beneficial owner belongs to an MNE group, the profitability ratio will be will be allowed to relate to the multinational, but as long as the multinational enterprises group's profitability ratio is higher than the profitability ratio of the beneficial earner. Why is that? Because they're concerned about the system being gamed. Rightly or wrongly, that's a concern. And you'll see in this provision and other provisions, there's always a concern that complexity carries a cost, and the developing countries are often in less position to deal with really complex provisions than the multinational enterprise, and that therefore there's some concern that there'll be gaming of the system if there's too much complexity. One reason why this approach has been taken. Automated digital services are any payment in consideration for any service provided on the internet or on an electronic network requiring minimal human involvement from the service provider. What minimal human involvement means, there'll be discussion in the commentary, and more probably than there is at the moment. It's up to the committee about what that means. And then there will probably be a list of indicative list of things which are constitute income from automated digital services, such as advertising revenue, digital advertising revenue. One of the issues was whether this should be a standalone list, which applies so that you don't have to look at whether it meets the normal test of being an income from automated digital services, particularly this minimal human involvement, or whether it should be like the provisions in Article 5, paragraph 2 and 3, whether it should be that it's you still need to look back at the basic definition, and we'll see where that comes out in the next draft from the subcommittee, which is effectively the same as the committee. This is what I'm talking about now, that's likely to be put in the article, and whether it's put in as a standalone list or just a list which still needs to meet the minimum human involvement issue will be determined later. There'll also be a list in the commentary of things that don't constitute automated digital services, including, for example, customised professional services. They might be covered by 12A. So this is, it's not trying to cover everything. And some people say, well, it's too narrow, but it's trying to be not overly complex, but to look at areas where developing countries think revenue is being lost because of the PE rules, which should be attributable to them. And one of the issues is that people say, well, why is it based on payments only? Shouldn't it be based on where the user is? And I think the conclusions of the drafting group were that that becomes quite complex, where the user is, tracing down where the eyeballs are in terms of the computers, particularly of people using virtual private networks and so forth. So they went for a payments-based approach. And some people say, well, that's deficient. And I think the response of the drafting group would be, it's imperfect, but it's dealing with what we see as a real issue. And maybe in the future, there'll be extensions to that, as this is an extension to Article 12A. But at the moment, it deals with some of the worst instances, and we think most of the worst instances will be dealt with where where digital providers get an advantage over non-digital providers.
Michael, could I ask a question? It's a naive question, but maybe because it's naive, it's helpful just as a clarifying question. Regarding paragraph 3, if you apply the profit ratio of the company, of the group, to revenue, you're already getting a measure of the profit that's contained in that revenue scheme. So the question is, once you already are measuring profit, why take a 70% haircut so that you only add 30% of the profit measure? The 30% is not of a revenue measure, it's already of a net measure of income.
Yeah, well, it's a very good question. I think the belief is, as I've said, that because the profits relate not just to the sales, but also to other elements, which as sort of manifest in payroll and in property/assets, that it's sort of a recognition of that. And I think what it is effectively is it's trying to be sort of not strangle the golden goose, but to ensure what they believe is still an appropriate level of revenue. But it is a point where there will be differences, and even those who don't like this provision at all, they like this election, but even in some cases they will say we like it, but it introduces new complexities. It's the issue of formulas make things easy to administer if they're good formulas. They're well crafted, but they do raise issues of policy. So it's okay.
So the assumption is that 70% of the profit accrues to offshore factors.
It's sort of recognizing that they will treat that as an appropriate thing. It's not a scientific conclusion, but it's a reflection of what they feel is a widely held view. It's sort of a compromise between the views that no value is created in the market and the view that yes, value is created in the market. But it is it's a blunt instrument, as they say, which people agree or disagree with, and as to how principles-based it is. But that's the basic idea behind it. I'll wind up fairly quickly for any further questions. The income is deemed to arise where the payer is a resident. This is saying that the focus is on where the payment is made. As I said, there's pros and cons on that. And we also have a special relationship situation, which is a UN norm where they say, well, if the amounts which are paid are not arm's length because of a special relationship, they can be sort of effectively adjusted. Article 12A, which is fees for technical services, excludes payments by individuals for services for personal use. There's nothing like that in Article 12B, because the feeling was, even in the case of personal use, profits are being made and they should be taxed. There's a recognition that the withholding mechanism in that case might be a little bit difficult. And they talk in the commentary about the approach taken in some countries, I think Argentina, for example, where the credit card company has the obligation to address the withholding in that case. But remember, in all these things, people forget, this is a sort of a maximum allowed by the treaty. It would be possible either to have a more limited approach in an individual treaty, or, as often is the case with treaties, not to fully exercise your taxing rights if you felt as a country that you don't want to apply the full maximum measure of taxation allowed by the treaty. So you can always have more generous provisions in your domestic law, remembering the domestic law is necessary to make this operative. I've talked about why it addresses the place of payment rather than the place of the users. And I think basically a simplicity argument and a risk management as to where they think the worst risks are. There are also some issues about the exceptions for PEs in the article, which are common in the UN provisions, and the issue of whether that raises the possibility of abuse or whether the normal approaches of dealing with abuse in sort of more robust post-BEPS treaties will allow abuses to be targeted. So the next steps are the minority view has been prepared, and that will be in the commentary, and it will be considered at the April meeting of the committee. then it begins its life as a model. It needs to be negotiated. It needs the domestic law to be in place. But for people who say, well, bilaterals take ages to implement, and some countries will never join this sort of treaty provision, I would say, first of all, if that country does not have a treaty with this developing country, then the domestic law will apply and there won't be a treaty that excludes it. And secondly, this is a signal. And I've been saying this for a while, and I was glad that I think the IMF picked this up. This is a signal from the developing world that they seek their proper place in the international norm-shaping environment, that they want a sustainable long-term solution that needs to reflect developing country views. They'll band together more than they have in the past, which I think the inclusive framework process is actually good. In developing countries hear each other and realise they have some common interests, even across regions. That domestic legislation is okay. It shouldn't necessarily be vilified, but of course we try to get it as consistent as possible for the benefit of business. That taxation based on presence in the market is entirely legitimate, as I mentioned, not a new taxing right that is a gift. It's something that's quite rightfully part of the armoury of developing countries and needs to be better expressed in treaties between countries. And that withholding taxes are a valued part of the furniture, but they should be moderate. And this time they've even gone further than normal and said maybe have a profit-based option that's not too easily gamed. And they certainly don't like thresholds based that only apply to businesses of a certain size internationally or a certain size in their markets. So that's something that developing countries don't like at all. It's not inconsistent with the OECD work, despite what people say, because the OECD work will, if there's a multilateral treaty for countries that join up to that, will definitely make sure that that overrides any inconsistent treaty, or it will turn off domestic legislation that's seen as inconsistent. And in either of those cases, you wouldn't have the Article 12b would not apply in that treaty relationship between two countries which were party of this multilateral. As I've said, don't assume that every country involved in multilateral negotiations will necessarily join. The other thing I'll just mention briefly is you would have seen the Facti Panel, the high-level panel on international financial accountability, transparency and integrity for achieving the 2030 agenda. It's a long title. The Facti Panel put out a report just recently which is trying to put tax, illicit financial flows more generally, corruption, etc. It's a broad term, illicit financial flows, to try to put them all in the perspective of sustainable development. It's an independent panel report. It's not a tax committee report. They spoke to some members of the committee, but as members, not as a committee. There's the web address of it. It's among its recommendations, a United Nations tax convention. It's fairly broad about what would be covered by that, but clearly they feel that there should be a UN tax convention dealing with tax transparency standards, but also more general issues, including, it seems, allocation of taxing rights. I put there what would it cover, because that would need to be further discussed, because there's not too much detail, but clearly it's meant to be broad. They're also suggesting a corporate minimum tax, and they're suggesting this shouldn't be too low. And this is something that a lot of African countries have mentioned in respect of Pillar 2, that if it's too low, with high taxing rates in Africa, I think it's usually between 28 and 35%, that if it's set too low, you'll still have the race to the bottom and the profit shifting. And finally, UN intergovernmental body, that it's not clear whether it would be an upgrade or a replacement of the UN Tax Committee, which is not governmental, people in their own capacity. And as I say, this is just a recommendation of this panel. It would need to be considered by the UN membership. And finally, regulation of enablers, such as lawyers. And I said enablers, actually, that may should be accountants, that self-regulation is not seen as effective. And this raises the issue of the ethics of tax planning and the extent to which ethics should be of tax planning should be drilled into to lawyers and accountants, and the extent to which it already is. The International Bar Association has already responded saying self-regulation works, and different people would have different views on that. So what's likely to come of it all? It depends on the membership. It'll be a vigorous debate. Countries and individuals are on both sides of these arguments, but I think it's very healthy to have these sorts of discussions. And that's been a long, session, so I hope we have enough time for Q&A. I think we do.